Welcome everyone, and thank you so much for being here today. I understand and I know that as business owners and our employers, you all are extremely busy, yet you took the time to be here today to expand your knowledge in the workers' compensation. This session is designed to help you understand your rights and responsibilities as an employer in Texas. Now, whether you're a subscriber or a non-subscriber, there are key things that you need to know and that you need to stay in compliance with to protect your employees and avoid unnecessary risks. My goal today is that all the information I provide to you today is clear, practical, and something that you can use on your day-to-day operations. All of the information that we will discuss today is all in compliance with the Texas Labor Code and the Texas Workers' Compensation Act. Hi, my name is Stephanie Saldaña. I've been with the Division of Workers' Compensation for a little over 8 years. Most recently, I joined the Learning, Development, and Innovation team as an engagement and training specialist. With this team, we will focus in providing educational material, resources, and CompCourses such as this one to better assist all of our claim participants. For today's presentations, we are covering rights and responsibilities for the employer. And so some of the information that we will be covering today to help you as employers in Texas is understand what is workers' compensation in Texas, know your rights and responsibilities under the law, recognize compliance requirements, and we will be referencing those Texas Labor Codes and Texas Administrative Acts along this presentation. If you need them or need to reference back to them, you'll have those available as well, either on the presentation or in the handouts if you printed those out. Know how to file accurate wage reports, learn about return to work support, and learn about available resources available for employers. Now, I'd like you to know that we did take some time to meet with some of the subject matter experts in certain areas so that we could gather this information for you all and provide you these resources that you can probably apply on your day-to-day employer operations. So what is workers' compensation? Well, workers' compensation is a state-regulated insurance program, insurance that covers employees who are hurt or get sick because of their job. Now, it pays for medical care, and part of lost wages and other benefits. Now, some of these benefits may also be death benefits, and this is a benefit for dependents when a worker dies from a job-related illness or injury. Now, workers' compensation helps workers recover and return to work. It also provides employer protection, so in return, employees usually can't sue the employer for damages, and this is called or known as the exclusive remedy. Now, the goal is to protect workers and their families financially while keeping predictable costs for employers. Now, workers' compensation is also governed by Texas law. So this is all the information that we will discuss today. Again, it is referencing back to the Texas Labor Code and the Texas Administrative Act so that we can better give you the information. We will be discussing timelines, timeframes for some of the information some of the rights and responsibilities as an employer. And you'll get that information, so if you need to go back to it and review it or maybe get the timeframes depending on your situation, you'll be able to do so as well. Now let's take it back and give you some information of workers' compensation, a journey through time. How did workers' compensation come about and why do we have workers' compensation? Well, back in the pre-industrial area, this is early work injuries back then, where employers often avoided liability. So the employers at that time would use common law defense like assumption of risk. So if the job that the injured employee was doing was dangerous and they knew it, well, technically they could say they weren't liable for that injury. Also contributory negligence. Now, if the worker was even at 1% at fault, they got nothing. And another common law defense was fellow servant rule. So technically saying the injury was caused by a coworker and not the employer, so the employer would not be liable as well. Now, during the Industrial Revolution, which was back in the early 1800s, there was, with factories booming, railroads and mines just growing, the injuries were also skyrocketing. So workers at that time faced dangerous machinery, long hours, and poor safety standards. Lawsuits were expensive and slow, and of course, they were rarely successful for injured employees. Now, if you think about it, families at that time were also left without an income, especially if the breadwinner was hurt. And this is where, back in the late 1800s, early 1900s, there's a push for reform. So the public pressure grew, the workplace accidents were becoming more visible, And both the labor unions and the progressive reformers pushed for a system that would protect workers from these endless lawsuits. Now, the employers also wanted a system that gave them predictable costs instead of unpredictable jury awards. And the first system started in Germany back in 1884. Now, Chancellor Otto von Bismarck, he introduced the first modern workers' compensation system, and this actually set an example worldwide. The United States then implemented workers' compensation system in 1911, and Wisconsin was the first one that passed its first effective workers' compensation law. Now, here in Texas, Texas followed in 1913. By 1949, every U.S. state had some sort of workers' compensation. In short, workers' compensation was born out of the need to balance fairness for injured employees and financial protection for employers. Now, just to give you some visuals of what the workforce looked like back then, the first image, there's loggers working to cut down trees. They're cutting down these trees by hand. This was back in 1905 at the Monroe Logging Company in Washington. You also see the women working machines, is huge machinery. This is in Boston in 1912 at the America Woolen Company. And the one that is the most mind-blowing for me is the coal miner with their mule. This was in West Virginia back in 1908. Now, these are coal miners that are working with explosives and in mines, yet you can see that they're running a flame from the top of their helmet. So do you really think these working conditions were safe back then? They really weren't. And industry was just getting started. There were a lot of work-related injuries, and of course, there were many fatalities during these times. Now, back in March 25th of 1911, there was a fire. There was a massive fire at the Triangle Shirtwaist Factory in New York. And it is said by many historians to be considered this to have helped the workplace safety legislation in the U.S. During this incident, there was 146 garment workers that passed away, and most of these were women. And that's where we come to the grand bargain, where the grand bargain is born. This is a deal where the workers get guaranteed benefits, and in return, employers get protection from their lawsuits. Now, the injured employee is guaranteed benefits such as the medical care, lost wages, disability, death benefits in some cases, without the need to prove that the employer was at fault. And the employer gets protection from most lawsuits by injured workers. They have predictable costs through insurance instead of unpredictable court awards. And employers and insurance have a reason to invest in safer workplaces, since fewer injuries, of course, mean fewer claims. As a result, have a no-fault system which balances a fairness for workers with financial protection for employers. And well, employers do have rights. And some of these rights are employers have the right to carry or not carry workers' compensation coverage. Now, Texas is the only state where workers' compensation is optional for most private employers. Now, this does create flexibility, but it also comes with responsibility. Employers also have the right for insurance coverage options. So an employer may purchase a workers' compensation insurance policy from an insurance carrier that is licensed by the Texas Department of Insurance to sell coverage in Texas. Also must be certified by the Texas Department of Insurance Division of Workers' Compensation to self-insure workers' claims, or join a self-insurance group that has received a certificate of approval by the Texas Department of Insurance. Now, employers also have the right to contest the compensability of a claim, so you will have the right to dispute a claim. Now, in order to do so, as an employer may file a DWC Form 004 along with a DWC Form 005. And we will be covering these forms shortly to give you some information as to what forms are exactly required in the process for that if an employer decides to contest the compensability of a claim, which is your right to dispute a claim. Employers may also be notified of these proceedings, so you have the right of a resolution proceeding and the right to attend these proceedings as well. Now, reporting fraud, employers may also report fraud. If you suspect that there's fraudulent activity related to a workers' compensation claim, it is, of course, your right to go ahead and report that and make it known that there's suspected fraud in a certain claim. Now, there's return to work services available to employers. So return to work service, we also will be covering along this application to give you just some information of what's available to y'all employers and how you can better assist your employees in returning to work. There's also, as an employer, you have the right to request reimbursement of voluntary payments. Now, in order to do this as an employer, you must meet certain circumstances and timeframes. Now, Texas Administrative Code 126.13, which is Employer Initiation of Benefits and Reimbursement, better outlines what these circumstances and timeframes are. So again, you must abide by these timeframes, by these circumstances in order to get reimbursed. And you'll be able to find the information again under the Texas Administrative Code 126.13. Now, as employers, you also have responsibilities. And so some of the responsibilities for employers are to notify employees of coverage and provide written notice. So employers must tell their employees that they carry workers' compensation insurance by providing them a written notice of coverage upon hire. Now, this notice must inform injured employees of their right to reject workers' compensation and retain their own common law right of action. And this notice must be in the wording and format prescribed by the Division of Workers' Compensation. Now, these notices are available for you all to go ahead and print out. They're in a PDF format where you can fill it out with your employer company information, and we'll reference those for you as well. Employers must also report injuries to their insurance carrier within 8 days from the day of. For Texas Labor Code 409.005, it stipulates that these injuries must be reported to the insurance carrier within 8 days from the day that the injury is a result of the employee losing time from work for more than 1 day, that the employee has been diagnosed with an occupational disease, or that the employee has suffered a fatality. Now, a written copy of these reports should be filed with the injured employee at the time that the report is made with the insurance company. If you're a non-subscriber and you have 5 or more employees, you must report injuries and fatalities. In order to do so, an employer would file a DWC Form 007. This is an employer's report of non-covered employees' occupational injury or disease. So again, if you are a non-subscriber, there's a form that you still need to file and comply with according to the laws and the rules. Now, employers must also file a wage statement. This is a DWC Form 003, an employer's wage statement. This is a document, the wage statement, where you were going to provide the employee's last 13 weeks of income prior to the injury. And again, this is an employer form, but it's very important that it is filed because this is what determines an injured employee's income benefits. And we will be discussing this one further along the presentation because it is an important form, especially from y'all employers. This one also does have a time frame, and it must be filed within 30 days of being notified that an employee is entitled to death benefits or entitled to benefits in general. Now, the employers must report any changes. So again, employers, if there are any changes in the injured employee's wages, on returning to work timeframes, those must be reported. Now, to report any changes, the employer uses a DWC Form 006. This is called a Supplemental Report of Injury. This report must be filed with the injured employee as well. A copy must be supplemented to them. And again, there are time frames of when you need to provide this supplemental report of injury, depending on what the situation is. So it must be filed within 10 days from the end of a pay period in which an employee's pay changes, 10 days from the date an employee resigns or is terminated, 3 days from the date an employee begins to lose time from work as a result of the injury, 3 days from the date an employee returns to work, and 3 days from the date an injury causes an employee to miss additional work after they've returned to work. Now, employers must also file forms timely. So we've mentioned a couple of them already. Very important that these forms are submitted timely within the required time frame according to the type of form that you're submitting and the situation, of course. Again, file the forms timely. Very, very important. Another responsibility for the employer is to post written notices in the workplace. Now, these notices that are posted by employers, they must be in the wording and format prescribed by the Division of Workers' Compensation. And if there are any changes, there's an insurance change, you had coverage and now you don't, all of these notices must be updated, and we'll be covering those shortly so you know and get familiarized with what notices are for what. But they must be updated if anything changes. So very important, make sure they're posted and they're updated if needed. Now, employers must also maintain and keep record of all reported claims. So employers have to keep record of these reports for 5 years or according to OSHA standards, whichever one is longer. That's the time frame that the employers are required to keep records of. And cooperate with Division of Workers' Compensation audits and investigations. So you may be faced in a circumstance where additional information is needed from an employer, or there's been a complaint and there's an investigation going on according to that alleged complaint. Well, you may hear from the Division of Workers' Compensation, from the Audit and Investigations Department, because they're needing additional information. It's very, very important that you comply and that you respond to them in a timely manner as well. And of course, a safe workplace. It's important that as an employer, you provide a safe workplace, to protect the life, the health, and the safety of your employees. Let's take a look at some of the notices that are required by an employer to use. Now, these notices are outlined under Texas Administrative Code Chapter 110, Required Notices, Subchapter B, Employer Notices. Now, starting with Notice 5. Notice 5 lets employers inform their employees that they are non-subscribers. So this is technically for employers that do not provide workers' compensation coverage. In Texas, this is the notice that you'd want to have posted in your workplace or business area, notifying employees that you do not have workers' compensation coverage. Notice 6. This one notifies them of coverage through commercial insurance providers. Notice 7 notifies them of coverage as a self-insured employer. And Notice 10 informs employees of coverage through a group of self-insured employers with similar industries who come together and get certified by the Texas Department of Insurance. Now, these notices you would be able to find under the Texas Administrative Code. They are available in a PDF printable format that you can actually download, and you can plug in your employer business information into them and use them as notices and post them in your place of employment. And we also have employer forms. Again, we've mentioned a couple of forms that are out there that must be filed and some of the time frames. Well, these are some employer forms that must be filed by the employer depending on each situation. So give you some information on these forms so that you know when the form applies to you and when to file it and within what time frame. We have the DWC Form 001 as an employer form, and this is an employer's first report of injury or illness. Now, this is the form that must be reported and must be filed within 8 days from when an employee has missed more than 1 day of work due to an occupational disease, an injury, or fatality. Now, the DWC Form 003, which we also mentioned earlier, is the employer's wage statement. And remember, this one must be filed within 30 days from the date an employer is notified that an injured employee is entitled to income benefits. Remember, this form is very important because this is what actually helps the insurance carrier determine an injured employee's benefits, if they're entitled to any income benefits. So again, this is the DWC Form 003, Employer's Wage Statement. DWC Form 004, we mentioned it as well as your right to dispute. Now, this is a DWC Form 004, which is an employer's contest of compensability. Now, this form must be filed along with a DWC Form 45, which is a request to schedule, reschedule, or cancel a benefit review conference. Now, just to give you a little bit more information, as an employer, of course, you have the right to dispute the compensability of a claim, but it's very important that before you do so, that you reach out to your insurance carrier, that you mediate and try to see what, the outcome and see what's going on with the claim and talk about the compensability of the claim prior to filing the DWC Form 004. Communication between the parties is very, very important. And so for this DWC Form 004, you do have the right to dispute, and you can do so. You can file this form, and then you can file along with a DWC Form 45. And it's very important that you all try to mediate and come to an agreement on the compensability. If that's not the case and you weren't able to resolve the issue, then at that time you can go ahead and move forward, request to schedule a benefit review conference with a DWC Form 45 and then this employer form, a DWC Form 004. There's also a DWC Form 005. Now, this form must be filed by non-subscriber. This is a DWC Form 005, non-subscriber notice to the Division of Workers' Compensation. Now, this form must be filed within 30 days of hiring your first employee, within 10 days of terminating your workers' compensation coverage, and within 10 days of the Division of Workers' Compensation asking for it. Now, this is a form, let's say you do have workers' compensation coverage and you decide to terminate it. Well, this is where your timeframes apply to you, and you must file this form to notify that you do not have workers' compensation coverage. There's usually a filing period for these forms. It's February 1st through April 30th of each calendar year. But again, if during the time frame or after these dates you terminated coverage, then of course you have those 10 days to file your form and notify that you no longer have workers' compensation coverage. Now, this form is also very important because when the form is filed with a division, if we have an injured employee that contacts the division and asks and lets us know that they've sustained an injury and they want to know whether their employer has coverage or not, if you file the form and the form is on file, then we're able to tell the injured employee, unfortunately your employer doesn't have coverage, or we're able to give them that information at that time. So again, it's very important that even if you are a non-subscriber employer, that you notify by filing the DWC Form 005 so that we know and we're able to better assist those injured employees that call us. And DWC Form 006, we also mentioned this one. This is the supplemental report of injury. This one must be filed if there are any changes in wages, employment, lost time, return to work, or lost time after returning to work. Now, DWC Form 007, this is the employer's report of non-covered employees' work-related injury. So this form must be filed within 7 days from the date that you become aware of a work-related injury, illness, or death, or from the date when an injured employee is absent to work for more than 1 day due to an on-the-job injury. Who is required to file this form? Well, a non-subscriber employer and an employer is required to file the form if you have 5 or more employees who are not exempt by workers' compensation. Now, if you have an injured employee that opted for not having a workers' compensation coverage, the form must be filed as well. And a DWC Form 074. This is a description of injured employees' employment, and it is a very important form because it actually goes along with a DWC Form 073. It is not an employer form, but I'm going to give you a little bit more information on how these forms work together. Now, a DWC Form 073 is not an employer form, but is a work status report. Now, you may or may not be familiar with it, but this is a treating doctor form. The purpose of this form is to communicate the injured employee's current work status, document medical restrictions, or the ability to return to work. Now, this form helps employers and insurance carriers understand the employee's functional capacity. Now, on this form, the treating doctor will provide you information such as the work status. Can the injured employee return to work with or without restrictions? If the injured employee cannot return to work at this time, what is the expected time frame? That'll be listed on this work status report. Any activity restrictions is also part of the form, so you are able to see, any restrictions such as posture, motion, lifting, environmental limitations, and medication-related restrictions will be listed on here as well. Any treatment or follow-up will also be on this DWC Form 073. So any diagnosis, next appointment, and any treatment plans, you'll be able to see that as well. Now, this form is filed by the treating doctor. They are the ones that complete it. It can be the treating doctor, referral doctor. You also see them from designated doctors, which are state-selected doctors, or required medical exam doctors, which are other type of doctors selected by the insurance carrier. This form is filed after an initial exam. When work restrictions change, so the form is being filed at that time as well, and after receiving job descriptions from the employer. And this is where we tie in the DWC Form 074. Now, this one is an employer form, and this form as well, the purpose of this form is to provide the treating doctor with a detailed description of the employee's duties at the time of injury. On this form, it's same information. Technically, the employer would provide the job description, which this helps the treating doctor determine if the employee can safely return to work. Because on this DWC Form 074, the employer provides, the job description, specific tasks, physical demands from the injured employee's job, environmental conditions, posture, motion, lifting, carrying, any tools that the employee must use or they're using during their workday, any exposure to elements. So this is information that as an employer you'll put or describe on this form for the treating doctor to review. On here as well, employer flexibility. So as an employer, is there any willingness to modify their duties or provide any alternate work for the injured worker? You can provide additional information like attachments, the job description or any alternate job options that you may have for the injured employee. Now, this form is completed by the employer's, technically an employer representative that has knowledge of the employee's job. And this form is sent from the employer directly to the treating doctor or the requester. This form does not come to the Division of Workers' Compensation, rather to the injured employee's treating doctor. So how do these forms work together? Well, the DWC Form 074, this was the form that informs the doctor about the injured employee's physical and functional demands on their job site. And the DWC Form 073 allows the doctor to assess whether the employee can safely return to work or not based on the information y'all provided on that 074. Now, together they support a safe and timely return to work process to ensure that the medical restrictions and job requirements all align together. And just to give you a little bit more information and description of how these forms flow together, so the employer completes the DWC Form 074, which describes the injured employee's job duties and physical demands. The DWC Form 074 is sent to the treating doctor, which helps the doctor understand the physical requirements of the job. The doctor reviews the DWC Form 074 and completes a DWC Form 73, which assesses whether the employee can or cannot return to work and under what conditions. And then the employer uses the DWC Form 073 to determine the return to work options. So as an employer, you may offer modified duties or optional work based on these restrictions as well. And so why is the DWC Form 073 important to employers? Of course, this is not a form for employers to complete, but it is important to you all as employers. Now, this form, of course, provides clear communication between all parties. So it communicates to you all the injured employee's current work status, if they have any medical restrictions, and it helps determine if the employee can or cannot safely return to work. And it creates a consistent way for the treating doctor, the employer, and the insurance carrier to share information about the injured employee's work status. It actually helps prevent misunderstandings and ensures that everyone is aware of the employee's medical restrictions and capabilities. Now, it supports and helps promote early and safe return to work. So having the accurate work restrictions for the injured employee helps the employer create safe and appropriate job tasks for these injured employees. This supports a quicker recovery and it helps reduce the overall time that an employee stays off of work. Now, it supports compliance, so it ensures that you as an employer, you're aligned with the medical recommendations and legal obligations, and minimizes disputes. So clear documentation helps avoid any misunderstandings within the employee or the insurance carrier. Now, as we mentioned earlier, as an employer, you have the right to dispute, but so does an injured employee. Injured employee, if they disagree with some of these restrictions, they all can also dispute the report, the return to work report. And so, again, it's in an effort to help minimize disputes, to help assist injured employees in an early, safe, and return to work, get them back in the workforce. And now, as far as business impact and how does this form impact you all as an employer, as a business, faster return to work is lower claim cost, better communication, fewer legal risks, and proactive planning, which is a stronger employee trust. And there's also additional employer forms. So these are employer contractor forms. These forms are agreement and declaration forms as per Texas Labor Code 406.096. And these are forms DWC Form 081 through 85. Now, the purpose of these forms is to define relationships between contractors, subcontractors, motor carriers, owner-operators, and or independent contractors. These forms help clarify who provides workers' compensation coverage, reduce ambiguity and liability in any work injury, and can include joint agreements affirming independent status. However, employers would decide which agreement is appropriate for their circumstances. And of course, you can go in here through our QR code and look at what form would apply to your type of business or employment and see which one would better suit your type of agreement. Staying in compliance. It's very important that as an employer, you stay in compliance with the Texas Labor Code and the Texas Administrative Act, which we continue to reference to this presentation. Now, we did take some time and gathered information from the Compliance and Investigations Program area to bring to you all some information regarding employers' compliance issues. Now, they gave us some really good information regarding some of the top compliance issues with employers, and some of the top violations for employers in general were violations of a Division of Workers' Compensation order to produce documents and reports. So we've also talked about the fact that the Division of Workers' Comp may reach out to employers either to gather information because we need a wage statement or just additional information that we may need. And oftentimes it's found that employers do not respond within a timely manner. So again, remember, there are timeframes to respond, all in compliance with the laws and the rules. And this is one of the violations against employers, that there's no response within a timely manner of these orders to produce being sent out. Another top violation for employers, it was a failure to report an injury in a timely manner. We've discussed that today. We've discussed the timeframes, when to report the injury, all again in compliance with the laws and the rules to better assist you and make sure that these claims are being reported in a timely manner. Another top violation was failure to file a supplemental report of injury. Remember, this supplemental report of injury also has timeframes of when to file it, when it's required to be filed. And of course, depending on the scenario and circumstance of your injured employee, when the supplemental report must be provided. And the number one violation against employers, failure to file a wage statement timely. Now, the wage statement is very important because this is the document that actually provides the insurance carrier with the injured employee's wages. And this is how the insurance carrier can actually determine the pay rate for an injured employee. This is a number one violation because they're not being filed within a timely manner. Remember, the wage statement, the DWC Form 003, they must be completed filed with the insurance carrier, the injured employee, and injured employee's attorney, if any, of course, within 30 days of the earliest of the date that the employer is notified that an injured employee is entitled to income benefits, or the date of the employee's death because of a compensable injury. Remember, this one determines income benefits for injured workers. And these forms must include overtime, bonuses, and similar pay if applicable. Now, the employer's wage statement must be complete and accurate, meaning that everything should be filled out on this form. Every single section, it must be signed and certified, and nothing must be left blank on the form. So again, part of filing this wage statement is that it is completed to its entirety. Also very important that the person that is completing this form with the employer is someone that will be available if the division needs to reach back out to obtain additional information. So again, it must be complete and accurate and must be filed within the required time frame. And if you'd like more detailed information on how to file a complete and an accurate wage statement report, we actually have a comp course available to you all that actually outlines the DWC Form 003 in detail and explains to you how to file a complete and accurate wage statement report. As an employer, of course, there are resources, and we actually sat with some subject matter experts in different program areas to gather some accurate information for you and resources that can better assist you as an employer. Return to work. This is a very important one. Return to work. Not sure if you knew, but of course, we just discussed the DWC Form 073, which is a form that you may have already seen or will be seeing from a treating doctor related to the injured employee's current work status. The Texas Department of Insurance Division of Workers' Compensation offers individual consultation, workshops, seminars, training, and our employer's resource guide. Now, you can find these on our website. They are available to you. You can find the resource guide as well. It's called Making Return to Work for you and your employees that you can actually download and print. This is assistance with the Return to Work program, for you all to be able to bring your injured employees back to work. Now, an employer that helps injured employees return to work, reduces their workers' compensation costs, retains skilled employees, eliminates absences, and of course avoids costly staff turnover. Employees who return to work, they heal faster, they keep their job-related benefits, reduce financial losses, stay employed, and maintain physical and emotional health. Of course, they can also avoid long-term disability. Now, it is the employer's responsibility, of course, to provide a safe work environment for their injured workers and their employees in general, to encourage the injured employees to return to work, to answer any questions that the healthcare provider may have about their tasks and duties. And we mentioned the DWC Form 074, which is the form, the description of injured employees' employment that you can supply the doctor with to provide them that information. Find meaningful work for injured workers while following any modified restrictions from the healthcare provider. So again, once you receive a DWC Form 73 and review what that work status is for the injured worker, you may be able to accommodate them or find them a job that aligns to these restrictions. And use return to work services from the insurance carrier. So the insurance carrier does have return to work services that you could take advantage of. Contact your insurance carrier and they can supply you with that information as well. Another resource that's available for employers is the Workplace Safety Program. Now, we met with subject matter expert in the Workplace Safety Program and gathered information for employers and resources that you all can use. Now, they do offer free and low-cost OSHA certified trainings. They also have OSHCON, that stands for Occupational Safety and Health Consultation Program, which offers safety assessments. They have accident prevention plans, consultation programs, safety inspections, and they even have an industrial hygienist service. We do have a CompCourse webinar with the OSHCON that on the top 10 violations, OSHA violations for employers that you can definitely take a look at and get a little bit more information on. Now, Workplace Safety does have a lot of great online resources and publications on their website that you can actually utilize in your business or workplace area. So all the information that we covered, that we discussed today, of course, it's all related to the Texas Administrative Code, to the Texas Labor Code, and we referenced those for you throughout this presentation. Now, there may be some certain scenarios or certain circumstances that apply to your day-to-day operations or to your specific scenario, and you may always go back, review the Texas Labor Code, the Texas Administrative Act, and you're going to find the timeframes that we discussed today as well. And this ensures that you're actually in compliance with the laws and the rules. However, of course, if you have any questions or you're not sure about something or you simply can't understand or interpret what the law or the rule is saying, you can always give us a call. That's what we're here for, and we'll help you with that. And so some highlights from today's presentation is workers' compensation protects employers and employees, and we give some information as to how you employers get protection and how employees as well, and how you can help your employees. Now that you have rights as an employer, your choice, protections, the dispute process as well. You have responsibilities, and of course we discussed the notices, some of the forms that you need to use for reporting and return to work services that are available to employers. Compliance, so you can avoid penalties, and of course we discussed some of those Texas Labor Codes and Texas Administrative Acts so that you can stay in compliance with the filing timeframes, forms, the notices posting, all of that will help you stay in compliance. And available resources for employers, such as the workplace safety, the return to work services that are available to employers, amongst others. Now, we also have our customer service line. We're also a resource that you can utilize. We are available at 1-800-252-7031. If there's anything as an employer, you can also give us a call. Any questions you may have, any resources that you're looking for, if you need us to send you any information, or just in general have questions regarding a certain process that you don't understand or that you need help with, we're here to help you. So you can give us a call at our customer service line. We are available 8 to 5 p.m. Monday through Friday, and we're here to assist you. Now, we'll now be answering any questions that you may have based on today's presentation, and we'll be with you momentarily. Thank you so much, everyone. Thank you for attending today's CompCourse webinar. I hope that you enjoyed learning about the employer's rights and responsibilities Just as a reminder for today, you must stay for the Q&A to receive the continuing education credit. And we will begin with the questions that are on the Q&A tab. So please feel free to enter your questions under that tab, and I'll try to get to everyone's questions. If by any chance we don't make it, I'll be giving you some information right now where you can send those questions or direct them to me to assist you. So for today, the first question I have here. Who conducts the audit and investigations for fraudulent claims in Texas workers' compensation? So that's actually done by the Texas Department of Insurance Division of Workers' Compensation Fraud Unit. So in order to, if you suspect there's any fraud, in order to report that fraud, you can actually fill out the form online. There is an email address where it can be sent to. There is a mailing address as well, that where it can be done. And there's a contact, there's a hotline, a fraud hotline as well. That you can find on the website. If you go under the tdi.texas.gov, there's that a tab for workers' compensation. And then you'll see a little tab also that says report fraud, or you can just go to the F under the ABC on the top, the dictionary, I'm sorry, the glossary, and you'll be able to find it there as well. So again, that is done by the DWC fraud unit. Then let me see. Okay, filing deadlines. What if the employee is injured, reports it, does not seek medical attention because they don't think it's an injury, but at a later time wishes to seek medical attention? Should the employee report it via DWC 01, even though it appears that there is no true injury? So yes, so actually the injury must be reported at the time that the injured employee reported that he was injured. So even if the employer does not believe that there is a true injury, it's really not up to the employer to determine whether it is or not. It is the insurance carrier that would investigate it and determine whether it is a compensable injury or not. So yes, it would be reported. You would not wait until the injured employee decides to seek medical treatment. That claim must be reported from the very beginning when the injury was initially reported by the employee to the employer. What are penalties or procedures if we used an outside insurance provider via an accounting partner? An employee told a supervisor of an injury, but the supervisor did not provide a report or report to workers' comp insurance. This occurred under the 1 year reporting requirement. I'm not sure if when you say an outside insurance, if it's your private insurance or which how it is that you obtain insurance. But remember, for workers' compensation, for insurance, it must be purchased. You must purchase a workers' compensation insurance policy that is licensed by the Texas Department of Insurance to sell coverage in Texas. Must be certified by the Texas Department of Insurance, Division of Workers' Compensation to self-insure workers' compensation claims, or must have joined a self-insurance group that receive a certificate of approval from the Texas Department of Insurance. So that's what we regulate. We would regulate if that is the situation. Let me see. Okay. So in this case, and I was trying just to better understand the question, if it is the scenario where this is a workers' compensation insurance, again, the injury must be reported once you've been notified. But if it's your own private insurance that doesn't fall under these circumstances, then we do not have any jurisdiction over them, and we don't regulate that. The timeframes that we speak about it is not something that we regulate. Um, just pulling up some of the questions here. how do you file the forms like DWC Form 005 and the DWC Form 007? Now, these employer forms can actually be filled out online. They're available on our website. So same thing under the Texas Department of Insurance, the workers' compensation tabs. There's a section for forms. Now, under this section, there's a section also for forms that can be filed online. And so the DWC Form 005, it tells you where you can send it. It can be online, and there's actually a link that'll take you to it. Also, you can do that via email, fax, or you send it in. But that actually you can do online, and it's an option that you can go through on the website. Same thing for the DWC Form 007. That form actually it also can be filled out online, and it's actually submitted. You create a profile under TextComp, and you can upload the documents, fax it, or mail it as well. So these forms can actually be filled out online as well. Okay, so this one says, is there a time frame to provide the DWC form 074 to the doctor? There's not a specific time frame. So if the doctor requests the form, um, and I'll get more information on that. I believe there's not a specific time frame where it needs to be sent over to the doctor, but I can check that for you. No, so there's not a specific time frame to you need to send it back to the treating doctor. But if the doctor requests it, it's in the best interest to send it back with, of course, the injured employee's job description, duties, and so forth to help the doctor be able to complete his report of the DWC Form 73, the return to work status report. So when the employer refuses a plan, what does the employer do? So I guess this one just depends. So when an injured employee is placed on, I'm not sure if we're talking about the light duty, the restrictions, when they're placed on a restrictions or light duty, and the employer or the employee, I'm sorry, does not feel that they can complete these light duties, they can't return to work even with the light duties. It's really going to be up to the injured employee to see if they can actually perform with these light duty accommodations. And if they can't, go back to their treating doctor and let the doctor know that they cannot conduct these light duties or what issue they're experiencing, even with the restrictions that they're on. And at that point, the treating doctor can decide to either remove them completely from work again, or give them additional work restrictions. And so it would just depend on the treating doctor restrictions, but that's an option that they have. Is they return to work and they're not able to perform those light duty restrictions, they can go back to their treating doctor and address it with them, and then the doctor can make a decision at that time. Um, okay, so if the insurance carrier is required to initiate benefits 7 days from the date of disability and or 5 days from the receipt of the DWC Form 69, why does the employer have 30 days to submit the DWC Form 003 wage statement? I mean, the DWC Form 003, that's the time frame, and that's what's stipulated in the rule in the 30 days. I can't tell you exactly why the time frames were done like that in comparison to like the DWC Form 69. That's technically that how it's written in the law. So I can't compare why some time frames are some required to pay in a certain time frame, and then the other ones are different. So for the employer's wage statement, again, it's 30 days from the date that you become aware that of the injury. And so unfortunately, I can't tell you why the time frames vary, but that's the way that it's being required, just given the situation. Now, the receipts of the DW Form 69, that's a report. that the claim has been established, the injured employee is going to treatment, they go to this designated doctor, and so that's the report from the designated doctor. So it's a little bit different because that's a report from a doctor, and the employer has those 30 days from initially when they become aware that injured employees has an injury or there's been a fatality. So it's two different things: the wages and the report of medical evaluation. Providers and exit worker. Okay, what is the best site to view that? What providers in the area accept workers' compensation insurance, so we know where to send the employees. So so there's several options. Injured employees can actually contact us here at the division or to get that information as well, or they could do that online. So what we have is a system where we can go in there and look for providers that are in the area for injured employees, and usually they call us, and employers can also do that because we can assist with that. We have a system where we go in there and we type in the information where the employee lives or in the area. And sometimes, if the injured employee is willing to travel a little further, they kind of give us that information, or you can give that as information if you're trying to help them out as well. And that's how we pull it up. We find that information, doctors in the area, and then we provide it to injured employees, or you employers if you're trying to assist an employee, and just gives you a list of all the doctors that are accepting workers' compensation that are in that person's city, or close to them or to that area. How do employers file required forms with TDI? So it just depends what form you're filing. I know we mentioned a couple of different forms through the presentation. For example, like the DWC Form 005 and the DWC Form 007. These forms actually have specifically where they're going. The best thing I can tell you is if you look at the form, all of our forms do come with an FAQ behind it. That FAQ specifically tells you where that form can be sent out. Some can be emailed, some cannot, some can be faxed, submitted electronically. It just depends. But the best advice I can give is each form will tell you where that form needs to go to and where it needs to be sent out. Since there's different program areas, they all do go to different program areas. And so there's not one specific place where you can send them, but it will tell you the form specifically that you're filing will tell you how to send it and where to send it. So the FAQ in the back is really, really, really good. It gives you all the details on the forms. Is there a list of the non-subscribers that's available? Yes, there is. It's on the website as well, on the tdi.texas.gov under workers' comp. There is a list on there. You can go through that through the website. And if I'll give you my contact information again at the end so it can better guide you where to find it, but it's on the website on the workers on our website on our workers' comp tab. What is the DWC 800-252-7031 used again? So that is our customer service line for the Division of Workers' Compensation. We get all sorts of calls in this phone number. We're the regulatory agency, but we get calls from employers, from injured employees, from providers. Just, in general, anything that's related to Texas workers' compensation, we get these calls. We can help you. If we don't have the answer for you or we're not the handling department, we will guide you and tell you, okay, well, we can't assist you, but this program area or this department can, or this is where you need to call regarding your question. So if you call that number, it's just, general customer service phone number, and we can either assist you if right there and then if we're able to handle your question, but if not, we also guide you and let you know where you would need to call or where you need to go if we can't help you. Let me see. Can I call to find out if I'm paying the correct fees for workers' compensation? Not the 1-800 number. Our customer service line cannot help with those fees for workers' compensation. In that case, I would direct you to call your agent who you handled or obtained your workers' compensation policy from. But we, the division, don't handle specifically the fees and what you pay or what you're being charged for your workers' compensation policy. If any employee is in workers' compensation with us, but he is seeking other employment elsewhere, would we report that to the adjuster? So yes, if you have a workers' compensation claim, you have your the handling adjuster. Of course, it's with the insurance carrier, your the carrier that you have as an employer. So of course, there's got to be constant communication between you and the insurance carrier, in this case, the adjuster. So if that's something you need to report to the insurance carrier that the employee maybe is no longer with you all, or that they now have a different employer, yes, that's something you can do with the adjuster. Iowa now requires a honor NR license. Is there a specific process now that is past 10-125 re-examination? Is it required? We only handle the Texas workers' comp. I'm not sure about Iowa, but if you have more specific question regarding if it's Texas, I can help you with that, and I'll give you my contact information. But for Iowa, I would not be able to assist you right now. Can a TPA report employer that is not providing information being requested? Yes, of course. Yes, a TPA can, adjusters, the insurance carrier, you can report, you can call us here at the division and let us know that you're having issues, maybe getting a hold of the employer or what you're needing and they're not providing it to you. So yes, the TPA, the insurance carrier can report that the employer is not providing information that they're requesting from them. We often get that with the wage statements when the TPAs or insurance carriers are trying to obtain wage statements from employers. We get those kind of reports and requests for assistance to help obtain those wage statements. So yes, yes, you can. Um, should an ADA case be opened when an employee is placed in a light duty and cannot perform the essential functions? As far as ADA, when it comes to light duty and employee, I'm not sure what the ADA, because in your place of employment, I'm not sure how to answer that. When there's light duty, I can't say that you can or cannot open an ADA case. I guess it just depends on a case by case basis. But when it comes to a light duty and you as an employer cannot accommodate the employee with those light duty restrictions, it's important that you notify your insurance carrier that you cannot um, accommodate them with those light duty accommodations so that the insurance carrier can go ahead and be aware. And of course, if you can't, then can reinitiate benefits to the injured employee. But that doesn't necessarily mean, can't tell you that that would require, it's not under workers' comp law that you have to open that ADA if you cannot accommodate them. But you must let the carrier know, I'm sorry, that you can't accommodate them with those light duty restrictions. If both the treating doctor and the specialist submit a DWC Form 073 form, which providers DWC Form 73 takes precedent? I'm sorry, I can't pronounce that. Okay, so for this one, if the injured employee has a treating doctor and they're seeing a specialist, the treating doctor is one that usually refers injured employees out to the specialist. So the treating doctor, the specialist is required, of course, to report to the treating doctor, and then the treating doctors would stay aligned with what the specialist is also saying. So in this case, the treating doctors report. And I do have a couple more questions here. On the chat that I'm probably won't get to today, but I'll give you my contact information. Thank you so much for joining us today. If I didn't get to your question, please reach out to me. So my contact information, my preferred contact would be via email, and that's Stephanie. I'll put it in the chat right now. Put it in here right now for you all. But it's stephanie.saldana@tdi.texas.gov. And again, I'll put it in the chat so you can have that traditional spelling. Stephanie.Saldana, Saldana, at TDI.TexasSpelledOut.gov. After the webinar ends, we also have a short survey that pops up to help us make these webinars the best that we can. You can please fill that out for us. I appreciate it so much. Thank you so much and have a great day.